What is the value of patents? Applicants spend millions of dollars obtaining patents because they believe they are obtaining valuable assets. However, the actual value of a patent is rarely quantified, let alone rigorously debated. That usually happens when there's a patent infringement assertion or sometimes in a licensing negotiation. However, Eli believes that understanding how the value of patents is actually quantified is indispensable for obtaining valuable patents. Welcome to Clause 8, presented by TradeSpace, a revolutionary end-to-end AI-powered IP management platform that helps companies unlock the value of their IP. If you enjoy this show, please take a minute to subscribe at voiceofip.com. For this episode of Clause 8, Eli invited the three most interesting experts that he has met in the valuation space. Our guests today are Michal Malkovich, Vice President at Charles River Associates, Alejandra Loaiza Delgado, co-founder and managing director at Econ Edge, and Mike Pellegrino, president and founder of Pellegrino Associates. Each of our guests are routinely called upon in the most significant patent IP disputes, including those involving global battles over the value of standard essential patents, government agencies, and Hollywood celebrities. Throughout this conversation, you'll notice that despite their different experiences and perspectives, they're all after the same goal: getting to the truth. And now, here's your host, Eli Mazour.
I wanted to bring all of you on for a while, and this is actually, I believe, the first panel that I've had on Clause 8. We've had debates, we've had wives and husbands, we've had dads and sons, but we haven't had a true panel where I don't know where you guys line up on the different topics we'll discuss. But the reason I wanted to have you all on, because I know all of your stories a bit, and I thought you have a kind of very interesting stories how you came to the space of valuing patents. And I think you have a slightly different perspective based on kind of what you do day to day. And obviously, like I mentioned, everybody obtains patents because they believe there's some kind of value to them, monetary or otherwise. But most people who spend their time in the patent world don't spend too much time thinking about exactly what that value is. And I thought, well, maybe we should be thinking about it a little more, and who better than you all to discuss it. So let's start there. Maybe we can start with your stories just a bit. Mike Pellegrino, you started in valuation, but not for patents. How did you end up dealing with patents?
Yeah, I came from engineering originally. I was a software developer, and I was doing some database work for a tax attorney in Fort Wayne, Indiana in 2002. And he had a client, it turned out to be Sony, and they had a massive manufacturing operation in Terre Haute, Indiana, where they manufactured Blu-rays and CDs and DVDs and whatnot. It's one of two facilities in the country, and it was incredibly automated. From the moment they piped in raw material until a skid was put on a truck, there was no human interaction, and it was all dispatched through ERP systems. So it was an intense amount of software that makes all of that system operate flawlessly. And in Indiana, if you're a business, you have to pay personal property tax on everything that you own every year. So if you have a $1 million machine, you have a 3% tax, not including depreciation. So you'll pay $30,000 a year just in your property tax payment. Well, software and other intangibles is exempt from that. So this tax attorney asked me to value the software embedded in the Sony equipment. And I hadn't been in valuation before, but I just kind of reasoned out if I had to defend it to a tax authority, how would I write the report? And came to writing something that was pretty close to USPAP, which is the Uniform Standards of Professional Appraisal Practice. I was just missing a few things, and that was just by coincidence. So I did that first report. I was about 28 years old. Sony paid me $100 an hour. I saved them a lot of money, and I said, I'm going to make a business doing that. While I was doing that, Indiana Tax Court came out with a law that said there's no valuation software embedded in equipment for tax purposes using a third-party appraiser. So I brought the issue to the legislature. Took a couple of years, but we got the law changed, and I helped write the state statute and the administrative rules for that. But while I was trying to get that law passed, I couldn't sell that service, and I was already committed full-time to Pellegrino, so people asked me, can I value other things? And like any good salesperson, you say yes, and you figure it out later. And that's how I got into valuation. When I came in, I was incredibly frustrated with what I saw as a lack of rigor in the profession, and so that was really what got me into more some of the writing and speaking, because it was really expressing things that I was seeing from an empirical perspective.
Michal?
Well, so it turns out that I was always an economist at heart. long before I knew that. And now I'm an economist at heart and by training as well, and by experience. But yeah, my foray into patent valuation in particular and thinking about patents came early on from the perspective of economics. And so started out as effectively a applied competition economist and got into work with, at that time, Judge Posner, who was already on the Seventh Circuit Court of Appeals, but he was sitting by designation on a lot of Northern District Illinois and some Wisconsin cases, where he became really interested in overturning the thinking about really anything that had a word intangible in it, right? So valuing intangible assets, intangible harm, consumer well-being, companies' intrinsic benefit that's not on the books somewhere in the context of litigation. And patents were one of the first and easy targets of his interest, and thus it became part of my interest as well. And that was, we're talking about early 2000s at this time. And after undergraduate work at the University of Chicago, instead of going to law school, Judge Posner said, hey, there's this thing called Law and Economics Consulting Group, go there. And I just never looked back. And it, really, really curious to hear the other perspectives that I see in particular in the marketplace today, how the world of valuation, and particularly in court cases and for negotiations and valuing patents for investment purposes, how all these worlds have, over the last 2 decades, have been both colliding and converging, and then sometimes really growing apart.
Within the patent community, Judge Posner gained a bit of a reputation for being not very patent friendly. I guess when you worked closely with him, was that your perspective, and did you have any kind of takeaway?
No, that's absolutely right. So my very good recollection of a couple of the first meetings were about making this distinction between the power of a property right as opposed to intrinsic value of whatever the property actually is. And so Judge Posner was really interested in that latter part. He thought that everything about the exclusionary nature of property rights, whether they're intangible or tangible, that's already been long established and of no interest to anyone. So the second question was, can we bring scientific rigor to that other interesting question that he had that related specifically to that intrinsic value? How do we value these things outside of? Can we do anything? Are there tools and methods that would be reliable enough that businesses rely on them, or that I can use in court cases as a trier of fact, or as a gatekeeper for that matter? So I think that's where his intuition was coming from. And then, we judge it by the outcome. And that's something that probably in particular we might hear later today about, the standard essential patents, because that was one of his particular pet peeves, like his pretty infamous conversations he would have with Judge Holderman, for example, in the same circuit. So, but yeah, you're absolutely right.
So Alejandra, you tell your story and you actually focus on SCP patents, so it's a good jumping off point. So maybe you could tell.
Yeah, for sure. I think I have a little bit of different background just because I'm the younger talent here. But just to start, so my background is in finance and economics, right? I have both degrees from Michigan State University. I'm a very proud Spartan. And the way that I entered into this industry was by coincidence. I was recruited right out of college by this small boutique consulting company, Toy for Partners, and there I had the opportunity to work with Mike Lasinski. And that's how my career evolved throughout the past 10 years. I've had the opportunity to work for small boutique consulting companies and then large, big consulting companies. And more recently, I founded my own company, Econ Edge, with my partner, Philip Klein. So what we do intellectual property valuation and focus on the assessment of economic damages. And as I said, across my career, I've had the opportunity to work across many industries and also different types of IPs. However, my main focus has been this standard essential patents and focusing in determining the fair, reasonable, and non-discriminatory royalty rates. I had the opportunity to work in very seminal cases, for instance, both the Qualcomm cases, the FTC Qualcomm case, and the Qualcomm class action. I've also worked for Huawei v. Samsung matter, the Conversant v. Huawei matter in the UK, more recently the Interdigital v. Samsung arbitration, and one of the most exciting things was that I was part of the Panasonic v. Oppo matter, which was one of the first cases ever heard about FRAND and SAP in front of the UPC. So that's how kind of my career evolved, mostly because the experts that I was supporting were involved in the SAP FRAND matter, so I kind of became the expert within that field. Interesting enough, when I was doing the Qualcomm class action, I was actually doing all the work. So I have seen every single license in this field. I've analyzed every single agreement that has been produced in the SAP and Friend Matters. So that has provided me a unique set of skills to actually see everything that is happening in this world.
And that's interesting, I guess. Overall, it was the field of patent valuation was more mature when you joined, but SCP obviously has been the hot topic over this time, and kind of that's where the cases and the debates have been. I want to kind of talk about the actual dynamic of being a patent valuation expert, and maybe I'll start with Michal because you mentioned Judge Posner, and he wrote, I think it was an interview with him, and he said patent litigation attorneys, they have a tendency to focus on infringement, validity, and then they bring in an expert who they either want them to say what, and I hope I'm being sure, but basically they pawn off the damages case on proving the damages on that valuation expert. Michal, can you talk about on a typical case that you work on, how does that dynamic work in? Where are you brought in? Are you told, hey, this is what we want, or how does that usually work?
Well, no, it certainly doesn't work that way. But there is something to be said, though, that I think most experts, and I hope myself included, we do have certain reputations for taking positions publicly, right, in the open court, that then may attract some clients who would not tell us what to do, but because we've said something in the past, they think we're going to say something similar in every single case. So in that sense, maybe a bit of a shopping happens, but it's rare. I would venture to guess that for most of us, in particular the members of this panel, we've built reputations for the quality of our work, and the clients who come to us, they know we're often going to argue with them as an initial cross-examination before we provide an independent opinion. But I think the idea generally is that for my clients in particular, they come because they're either users of the technology and they're really interested in how technology actually fits into their business model and into the value of the products they offer to either the public or downstream in the industry. And that creates a whole host of additional challenges that you sometimes don't see necessarily explored in, say, a typical court case, where you have much higher standards for things like anything from coin-joint sales to you're not going to bring relationships with the industry or with competitors or with partners under the standard valuation methodologies. And so when I got brought in on cases, it's because the client is looking for, say, a regression analysis, or is looking for a consumer survey, or is looking for a coin-joint study, or is looking for an experiment where we would actually model products with and without the technology, either realistically through existing sales channels or hypothetically through creating focus groups to value technologies. And then typically in my practice, I don't take everything under the sun in the context of patent valuation onto myself. I typically partner with others on topics such as discovery on licenses in the world. Who else has similar technologies or comparability analysis? Are there other licenses out there, or have there been, for a particular product, and how can they inform your own valuation? I work often with investors into companies that are particularly interested in, for example, spinning off various technologies and patent portfolios to either collateralize them as debt or to issue separate special investment vehicles. They have very different mindset into how to extract and how to develop a value for a technology or a patent. And so my role is to provide them one input, which is forget all that other stuff that you guys are experts in, including the probabilities of validity, infringement, utilization, scope rights, geographic rights, things about duration, IPR type considerations. I'm going to provide you with, assuming you want to continue using this technology, here's what it means to your business, here's what it means to your product, here's what it means to your partners, here's what if you don't do that, here are some of the alternatives you'd be pursuing instead, here's what the delay in implementation would cost you for, say, not licensing something for a period of time. I try to typically, and whether it's in a court case or in a negotiation or in a business decision-making for, say, an acquisition, typically that's what the clients come to me for. And that's sort of the services I specialize in.
So my sense is that usually if there's a litigation involved and the litigation attorneys come to you, they already have some kind of theory and they think that you'll be able to provide kind of the evidence to support the theory of damages.
Right. So one of the examples that's sort of on top of my mind is when discovery happens in the case and turns out that there's not a single license produced in the case that may be even tangentially relevant.
Yeah.
That typically, at least the attorneys I know, that sort of rings a bell and say, okay, we like the market approach. We don't have it here. So how can we make some of the other approaches? And we don't like the cost approach because very few patent owners like the cost approach. So how do we make the income approach the strongest possible? And I think oftentimes that makes them call me because there isn't something else to hang their head on. And then if there in fact is ability to create, so to speak, develop evidence that didn't exist before as part of discovery, that's where I come in. And sometimes we'll develop evidence and nobody likes it except for me because it's the truth. And then they say, okay, at least we tried.
Yeah.
And then hopefully they come back again. And often they do. But ultimately, as you sort of, I think maybe you tuned it in at the beginning of your question, that we all have our reputations to protect and we're here for the long run. So we're not just going to say whatever the client wants us to say.
But I guess one thing that I wanted to add to your discussion is, I think as experts, right, we want to make sure that we're getting the right answer or getting close to the right answer. So for instance, although we have reputations to have said things in open court in one way or the other, at the end of the day, as an economist, you want to get to the right answer of that valuation. And I think as you were talking about doing fact discovery, normally what we do is we do that wish list of like, this is all the materials that I wish that I could have to make sure that I can analyze whether it's a cost approach, a market approach, or an income approach, to make sure that you have. But at the end of the day, as an economist, you want to develop the model that best allows you to get to the correct answer and present that in an independent way. And of course, I think like the courts have been very specific about this, and it's like we have to make sure that it's tied to the facts of the case, right? So there's where the fact discovery is so important in our profession, because if we cannot do it, then we're out.
Yeah, I second that without any question. And the only thing I would add is that there's, in my practice, because it's so sensitive to the outcomes, like oftentimes the client and I myself don't know where the exercise is going to lead. There is also this extra step of, with a sufficient degree of economic and professional certainty, that I can actually put some statistical or other type of certainty on the opinion that I'm offering, because it does not depend on the license that already exists, for example. So there's a bit of where I may not feel comfortable. Even if I develop the analysis, I may not feel comfortable saying, hey, this is my point estimate, but I will not defend it for the purposes, say, of a Daubert proceeding, because I don't think we have sufficient economic or statistical tools to come up with an opinion that's certain enough.
So the law says that we have to be within horseshoes and hand grenades, and that's undefined. And not knowing the law, I had a motion in limine. I've had one exclusion in my life, and it cost me $750,000. So we don't trust the lawyers anymore. So for me, in my shop, because the lawyers generally, I mean, think about it. If you're a wildly busy trial attorney, you're doing 3 cases a year. We do 15. So we have way more practical knowledge of the cases. I've actually built a database of motion in limine decisions. And so if we draw a particular judge in a particular district, we understand what the law is and how they're going to rule on things and how that varies for comparability licenses versus apportionment, versus the thing that nailed me was an issue of first impression at the time, which was part of the hypothetical negotiation, which is a tail wagging the dog. Yaros wrote about it years ago. So the problem that we see from my chair, I like the statistical analysis. People say things are unreliable. Well, as soon as you say that it's unreliable, you have this issue of what's your baseline? You can't measure reliability unless you know a baseline. And so a lot of attorneys and even experts say something's unreliable and they have no clue what they're talking about because they've never measured it. If I generate something that's within 70% of my end target, my known, 30% of the time, is that reliable? Maybe. But if I generate something that's within the target 80% of the time, that's pretty doggone reliable. And, that level of sophistication is not very common in valuation. And that was really, when I came into valuation from an engineering perspective, we were a lot more rigorous on the scientific method and making sure that the science and the problem domain aligned. And it was less rigorous than I was expecting when I came into valuation, and even less so in litigation, because the rules of the market are often divorced in litigation. The degree of confounding court decisions, for example. Federal Circuit says you can use comparable assets in one case, but they say comparability only fits a very limited manner. In most cases, we can't use a comparable license at all, unless it's a naked patent license. So you get these distortions that come into play. Michael talked about something earlier about experts generally wanting to come in, and it's their reputation that they guard. And I'm more cynical because I've been fired from a bunch of jobs because I won't take a particular position that the retaining party wants, or I won't even get hired, and that's all right with me. But what we find when we do a lot of checks, especially with certain experts, we find that they take differing positions depending on the matter, and they use the cloak of secrecy to protect the transgressions. So we read a lot of transcripts. So when we draw a particular case, we're actually going to pull what somebody says in another jurisdiction, in another trial, and that's under oath, and then that tends to conflict in many cases with what we see in the real life. So I find those are rather interesting unless there's some manifest difference in facts, and sometimes there's not. I was on a case once where somebody said a company was comparable, and then 6 months later said the exact opposite in the same type of tribunal. And so that sort of thing unfortunately happens a lot because people, I guess some of them have to make the mortgage, right? And they do what they're told. So like I say, I'm a little more cynical on that, but there's a data-driven approach to that. So how do we use data fundamentally to inform the attorney, Eli, which is the opening question, about what the case value is? From my chair, we see a lot of cases where they come in with good infringement reads and bad damages models. And it's because they overestimate the apportionment contribution. They overestimate what the range of coverage is. They don't have the infringement nailed right. Those are all things that it really would help an attorney if they were doing litigation to address that way earlier.
And what would your recommendation be? Let's say somebody has a new litigation. What should they call a damages expert right away?
Day one, before the case is filed. Figure out if the case is even worth filing. So call any one of the folks on this call and just get the honest answer out of it. But once you do file the case, then I see a ton of error just in the discovery process. And there's motions in limine complaining about me out there that are kind of funny to read. And I can't talk about the particulars of it. I can only speak about what's public. But it really gets along the lines of, you stop telling lies about me and I'll stop telling the truth about you. And the issue is the amount of discovery abuse that we find, dishonesty in licenses that were produced, hiding data. These are the sort of things that I encounter regularly. And a lot of that's enabled by the litigating attorneys not asking the right questions. So they'll say, give me comparable licenses. Well, who defines comparability? It's not even defined in the discovery request. And that's fine. So the counterparty is going to make their own definition of it, and all licenses are going to be less than $1 million, with one or two above that just for gravy. And that's a fairly standard pattern of behavior that we see. But what's the law actually say? Who determines comparability for a license? It's the economics expert. So if you sue big tech company and they have 3,000 licenses, I am technically allowed to get all 3,000 of them. And it's my determination, not the opposing attorney, that decides, and they're only going to pick the ones that meet their filter, which are low dollar, so you get anchoring bias to distortedly low damages. And we see that sort of behavior a lot.
Yeah, these are actually really interesting too. What you've in tune with licenses. I mean, I'm often facing same exact issues, including where I'm a proponent of an expert reviewing all the licenses and making a determination one way or the other. And on top of that, there's also a lot of shenanigans I found in the last 5 to 6 years where a lot of licenses are produced, but then when you dig deeper, you may get lucky and notice that half of these licenses were never actually per se consummated, and there's no evidence of any royalties being ever paid, for example. And lawyers are very good, or maybe the companies are very good about hiding these facts. So these licenses, they exist on paper, but are they truly comparable if nobody really acted ever under their license? But that takes an extra effort in discovery and really clever attorneys to be able to either work with a good expert or know to ask these follow-up questions and seek discovery on, okay, show us the actual royalty paid under these licenses, because if nobody ever paid you, who cares what the nominal is included in the license? And there's a few other examples like that, but yeah.
Yeah, there's a funny motion in limine against me maybe a year and a half ago, a Houston case against Apple. So we're taught in middle school, if A equals B and B equals C, then A equals C. It's transitivity. And so my client had a technology that was similar to Vernetics. And Vernetics, Apple disclosed a license. They didn't disclose it to us, but they disclosed it there because I pulled the trial transcripts and I read the trial transcripts for all 3 trials. And so I used transitivity because if that license was comparable in the technology in Vernetics and we were looking at the comparable technology in our case, well, then that license that was undisclosed there was actually comparable as well under transitivity. And they did not like that theory at all. In fact, the motion in limine speaks to it, and it's public record. But that's the sort of stuff that you have to do to discover the type of, to keep folks honest, I'll say it that way. And some of it is folks that don't have a full view of the world that you can when you've got a massive investment in data like I've done. But that's why I did it. It's to have better information for valuation. It wasn't even litigation focused, but with that better data, you can then get to a truer value of what people's business need is for a technology, because that's what we're trying to get to at the end of the day. What's the value of that particular technology in a given context?
Yeah, so I want to ask Alejandra about that, because obviously I think the fact that you are focused so much on SCPs, in some ways, I guess, it's narrow, right? You know that if patent is infringed, your standard technology is being used, maybe it's somewhat easier to count the units in which it's put into, but you look at these cases, right? The ones you mentioned and been involved in, and they've completely different views of everything, right? And I think all of you mentioned you're trying to get to the truth. I guess maybe you could shed some light, like how are their views so different at the end of the day?
How do you get to the truth? My truth is different than others' experts' truth. I would say that one of the interesting things for me to have worked at the Qualcomm case was that every single party issued all the licenses that were out there. So I really was able to analyze the full spectrum. It was not only Qualcomm licenses, it were the Ericsson licenses, the Nokia licenses, everything is public record. So they issue all those licenses for us and we analyzed it. And I think one of the big issues that we see in standard essential patents and friend world is that when you have big licensees like Apple, Samsung negotiating with Ericsson and Nokia, those licenses tend to be a little bit more tricky and convoluted. It's never straightforward. Normally, those licenses are lump sum agreements that not only involve the SCP portfolio for cellular standards, but it may involve HVC, other video codecs, all of that. So as an economist, it becomes really tricky. Can you actually derive a per unit rate out of that license that is comparable? And I think that the discrepancy between the experts occurs there. How you're analyzing these agreements that are very convoluted on purpose, because nobody wants to figure out exactly on a per unit rate how much Apple is paying or how much Samsung is paying. And I think the discrepancy is not itself in the methodology. I think that overall in the industry, specifically in the SCPs, everybody has agreed in the unpacking methodology of those agreements and how to do it. But it's just the discrepancy between the truths of the experts comes into play on the assumptions that you're making to create a projection, the assumptions that you're making, or the value of the portfolio. Specifically, another complexity that we see in SCPs is that they are cross licenses. So then it becomes another hurdle to do because it's not a direct license. So you have, let's say, Apple and Ericsson sign a license. So you have Apple giving their portfolio, Ericsson exchanging portfolios, and you need to figure out what is the balance in payment, how the portfolio exchange ratio works. And then the data issue of what is the value of each company portfolio becomes a whole nother set of complexity. So I think when regards to the methodology, I think we can mostly agree what is the basic methodology of unpacking those agreements. It's just a matter of the assumptions that we made and how each expert is reading the data and understanding the data. I think, for instance, portfolio strength ratios when it comes to cross licenses is one of the most debated aspects in this industry. What should we use? Should we use declare SABs? Should we use deeming SABs? Should we use approved contributions? Should we do Avantia style and do a combination of? And what is the correct way to measure a portfolio strength ratio it's where the truth becomes a little bit ambiguous between the experts.
So that's interesting. I think maybe the takeaway there is if a company only has patents covering only standard essential patents for telecom, it might be much less valuable than if they have these covering different technologies and non-standard essential and standard essential way as well. Is that the overall lesson from that?
It just becomes a little bit more convoluted. For instance, for when Ericsson licensed Apple, they don't do what Mike was saying, a naked license. It is a license that is very convoluted. It not only licenses standard essential patents, it licenses other non-standard essential patents. It not only licenses cellular steps, but it does HPC. So it becomes really hard as an economist to figure out what is the correct answer. However, I think that as economists, we have developed tools and mechanisms to make sure that our assumptions are bulletproof or our assumptions are reasonable. That's a big thing in the industry. My assumption doesn't have to be perfect. I don't have to be able to predict the future exactly or precisely, but I need to be able to have to make an educated guess that is reasonable.
So, Michal, I think in the beginning you mentioned that you don't try to look at patents differently than you would at any other things you're involved in, which I know you're involved with other IP and anything. But do you think that there's things that you see from valuing other types of IP or being involved in other types of cases, which you think, hey, would work better if patent world followed this kind of...
Well, it's really interesting because I actually think that the world of standard essential patents has actually fewer artificial barriers to a proper contribution type analysis. And the way, for example, I think economists have been thinking about standard essential patents, in particular, when there is a lot of, I think, both jurisprudence, but also thinking about standard essential patents from both the contract perspective, but also from the perspective of the patent law. And those are sometimes not exactly the same, but they reinforce each other and they learn from each other. So if you think about standard essential patents in, say, cross licenses, I think Mike and I are both old enough to remember when both Apple and Ericsson were practicing entities, and those cross licenses meant something completely different than what they mean today for non-infrastructure equipment, for cell phones specifically, for example. The three of us on this call have had pleasure of being part of some of the most exciting multi-billion-dollar proceedings that nobody has heard of, other than through maybe a disclosure to the SEC because the event was big enough that it had to be disclosed to investors. But we literally valued portfolios of tens of thousands of patents for some cross licenses in SEP space that never reached the courtroom. And that oftentimes, I'm sure all three of us have to bite our tongues when we get involved in litigation because we know something is not true, or we know exactly what went into some of these licenses that we now review for the purposes of court cases, but we're bound by various confidentiality stipulations. But I think in those contract cases in particular, if they're in arbitration or even if they happen to be in courts that are not so friendly to, or they're friendly to protective orders, I think there's a lot of lessons that we learn about what companies really care about when looking at these portfolios, in particular when they're practicing entities. I'm still struggling with bringing true economics to cases in which there really isn't any interest in utilizing of the technology, but it's more of a true kind of either hold up or hold out type situation, or where patents are purely investment assets for advocacy groups that are not particularly interested in anything but monetizing. I think it's a little more challenging there because there's a lot of value that these patents generate that is difficult for an economist to capture, given the legal framework we're working in. So that I think I don't really have too many teachings to bring there. But for, I think, just general competitive value type analyses, I think surveys are an easy way of adding additional point to consideration. I don't think they're dispositive like some people think, but I think for some products, they do bring interesting perspective, especially in cases where product is the patent. I think they're very interesting in eliciting the actual value of the technology. I think some of the issues...
And survey, you mean just for maybe people who are not... Mm-hmm. A survey kind of some kind of study which determines what is the value that, I guess, the public places on a feature.
Right, exactly. Like, so how do consumers actually value a particular technology relative to some benchmark of a different technology, or this technology simply not being there? So depending on what the benchmark is, there are many interesting questions you can ask about your ability to create welfare, your ability to create pricing power, your ability to create a moat between you and competitors, your ability to create a differentiated marketplace. So those are the kind of questions that surveys can help you answer, and those would be an input then to, say, comparable licenses into an analysis of, okay, what can this mean in this particular case or context? So I'd say the one thing I'll be kind of really curious to hear from both of the other panelists here is in the context of how you think about patents and standard essential patents too in court cases, whether it actually matters from your valuation perspective at which point in the supply chain the patent is being valued at, given that once it is licensed, you're effectively covering everybody else's uses of it?
I can start that. So there's one thing I'd like to add, Michael, to what you said, conjoint survey stuff. We've used that in cases. Apple Wyland's really a seminal case on how to use that properly. But the other one that we use a lot is hedonic price analysis, which is just a fancy way of saying multivariate regression, where your dependent variable is the price. They've been doing it for over 100 years. They started it in the auto industry, but it's really slow to catch on in the legal circuits. But we use it in legal as well as outside of legal for pricing recommendations and whatnot. And what's really nice about it is it gets rid of some of the issues that exist when you start unpacking licenses, which the first and foremost is, how do you know the license was priced correctly in the first place? And the general answer is it's not. So most of the licenses, it's an easy test. You think about who actually sets the price for licenses in any of the major companies, and then look at who's actually doing major writing and speaking on valuation in the IP community. It's none of the people that are making the decisions. So they're not the thought leaders in the space. Maybe the closest was Raz Gaditz working for Motorola for a little bit, if I'm remembering where he was. But the point is that a lot of the data points that are used to negotiate those licenses don't really tie to anything but administrative convenience. So how do you start bringing clarity to what the value of it is if you have imperfect and so even say compromised or polluted data points to reference? So the first is we look at the technology itself. What does it actually do? So I was on a case that involved FRAND patents. I was working for Avaya defense side against Network One years ago. And I actually found that in the IEEE notes that the comparable technology they were considering was 75 cents a unit. So we had a good market established base point that I could use. That sort of data exists. It's out there. So let's say I'm doing something in video compression. Well, all of those different patents will map to different tools in a video standard. And each tool is going to bring a certain degree of compression. And this is something that a lot of the SEP analysis does not take into account right now. But if I have one patent and 10% of all compression that comes from HEVC comes from my one patent, it's worth a heck of a lot more. Why don't people do that analysis? Because it's expensive. Is it expensive as spending $100 million on a FRAND litigation? No, but that is the difference in how people try to administrate the cases. But it really gets to a bottom-up analysis. And the beauty of that is it's auditable, it's testable, and you can test a codec with and without a feature. And yeah, compression goes up or down 10%. So it's very clear. Then all you need to know is, well, how many bits are you sending and what's the value of those bits that you're sending and how many are you saving? And the math is very easy. We do a lot of early stage valuations where there's no proxy in the market. And that's the only way. You have to look at what is the benefit of that particular technology. That takes a lot of work and it costs a lot of money. So it's really hard to do that for a lot of companies that have competing demands for the dollars.
Right. I'd say that Mike didn't mention it yet, but the tool I use from probably Mike as an engineer remembers that pretty routinely now, whenever I have to actually implement a discounted cash flow model, I almost never now not use a Monte Carlo simulation, at least for some of the key inputs to provide some measure of spread and not statistical confidence, but just confidence about the stability of the model itself. And that comes from engineering. And I think it's a useful tool in patent cases and in the valuation in general, even if it's for an arbitrary set of parameters that you are not as comfortable defending as you wish you were. So you can provide some informed alternatives and test them with some level of rigor, or at least computational power. And those will be exercises that are cheaper than developing a fully fledged hedonic regression model, but also more expensive than some of the clients may be willing to engage in. So there are things in between.
So Alejandra, I'll give you a chance to talk about that. But I guess with you, it's interesting about what Michal and Mike were talking about in terms of what is actually the value of this technology, right? Because some of the arguments that you hear about standard essential patents is, well, they're calling it 5G, but nobody actually needs this technology for developing But then you see some of the same companies making this argument, then you see an ad, it's a 5G phone or whatever. So, so I guess it's a more complex topic when you have something like that, but how do you think about that?
I'm glad you brought it up. The topic of what is a smartphone that is 5G is something that we're going to, Econ Edge is prepping a whole article on this that is going to be launched in April about this exact point. But I would say a lot of things that we see is 5G as an advertising point. So if you look at a 5G devices, we can have devices that are worth $1,000, $800. But now 5G is also cannibalizing the market, and we can have 5G devices that are $100. And what we have seen in the industry has shifted a little bit from ad valorem royalty rates to per unit rates. So under a per unit rate, fixed per unit rate methodology, a $100 phone that is 5G, and let's say that $400 phone that is 5G would pay the exact same royalty rate. And a lot of my colleagues could argue with me that that is non-discriminatory. It's great. However, the question that I always like to make to people is, are those phones using actually the same 5G functionality? They say that it's 5G. When I go to AT&T and I see my $100 5G phone, it says 5G, and my $400 is 5G. So as a user, it may be perceived that it is the same thing and we're using the same technology. However, when you go back and you actually do a little bit further study, there's some conclusions that are slightly different than this assumption. So for instance, what modem is being used in those devices? And let's say Qualcomm, one of the largest modems designers in the world. It is true that the same modem that goes into a $400 device is the same as it goes to a $100 device. And when you actually do a little bit of research, you can see that that is not the case, right? 5G is mostly divided in two different rates, the sub-6 and then millimeter wave. And when you look at the modems, the $100 device modem doesn't have millimeter wave, which is what allows you to do the extra step, the 5G advanced. But the $400 device does have that. So then it is fair, it is truly non-discriminatory for those two phones to pay the same rate, although they may not be using the same type of 5G. And at the beginning, a lot of people, I think that there's a misunderstanding in the industry because when 5G is launched, only the top tier devices have 5G. And most likely there is some similarity of what chipset they are using. But as 5G cannibalizes the market and starts getting share of the 4G devices and going into the low-end devices, that becomes a huge problem because, they are all technically 5G, but they're not necessarily using the functionality of 5G the same way. So I think for per unit proponents, I think that as an economist, you need to do the extra step in being like, how is this technology being used and how it is applied? The same thing was true with LTE. LTE had different categories that allow you to do different download speeds. And each chipset has different releases and different categories. So although everything is called LTE or 4G, it doesn't necessarily mean that they are using the same technology. And really understanding that is crucial because at the end of the day, competition is based on the segment. So although the $100 device is 5G and the $400 device are called 5G, they are not necessarily the same type of 5G.
That opens a can of worms. I like what you're talking about because it really gets to an a la carte fashion for how you price anything. And whether it's SEPs or whether it's in litigation or out of litigation, these are things we have to address with valuation all the time. Somebody says, well, and I had to deal with this on a power over Ethernet case. It was a safety thing. There was a boundary condition. And so it's used 1 in every 10,000 hours. Does that draw the same weight as something that is used on error correction 38,000 times a second? No, or used at all. And you get these really interesting, what's the value of handover for a fixed-base wireless device? Well, none. They don't need a handover because it's fixed. It's not moving. So you could compartmentalize into different buckets. All right, if let's say the rate's $1 for whatever it is, handover is 50 cents or keeping the thing connected is 75, whatever the amount is, and you allocate it based on the standard. The analysis that goes into that is really, really interesting. And that's how we price some of our patent features over the years, because you can look at, well, that thing affects call quality, and we showed one patent one time, if they took it out, it would cost Verizon a penny a month in a subscriber. Now, Verizon didn't know that. They didn't hire us, but that was the analysis that we did. And so I like what you're saying because it allows you to get a really discrete range, and it removes a lot of the arguments that people say, well, I'm not using the benefit of everything, so I shouldn't have to pay for it. I don't think that the market would tolerate it, though, and I don't think that they're sophisticated enough to do pricing schedules at the level of fidelity. It's hard, too. If you've got a lot of patents just on that one issue, 80% of the patents are going to be in the radios, and those are less discretionary than some of the others. But maybe you can do it at mid-band and millimeter wave and low band, different pricing tiers for those.
I think it all depends on how detailed you want to get. And I think a lot of people that are against this idea would say, oh no, when you're negotiating a license, this is too time consuming, it's too detailed, nobody's going to actually go and investigate this type of thing. But my rebuttal is something that I think is really interesting is in the S&P industry, friend, all those companies tend to use IDC data, has been used by several courts. And the IDC data does allow you to do 5G categorization between sub, 6 GHz and millimeter wave. Like they have that category embedded in that data. So like you don't have to go chasing every single chipset for every single device, right? You just have to pay maybe a little bit more for that description, and you can run an analysis that is able to at least distinguish between those two type of data rates.
There's so many moving pieces in these models. I remember working on some projects with, well, that was back in the day where, speaking about data, which I love IDC, but I wish in the modern day, say strategy analytics, which used to be a big competitor with similar quality data, would produce similar quality data for comparison, because you could test your models then and see that quality of the data actually matters. But with that aside, I think there's a lot more opportunity to combine data still in this modern world for hedonic regressions in particular. I mentioned IDC data. And then the second step is, well, let's also have a very sophisticated way of comparing, say, cell phone plans, which sometimes are pricing of plans is what turns on and turns off some of the auxiliary features that are often subject to patent litigation that ultimately read on a standard. Combining the data sets and then being able to at least bucket certain things like, hey, here's your thing on the radio antennas, but here are the things how radio antennas and specific type of frequencies affect your battery life, for example, and that may be important to consumers. Things of that nature that I think there's a lot of unexplored still modeling to be done that I think in some of the bigger cases and some of the larger portfolio type negotiations, I do think that companies have appetite for no stone unturned, because while the costs are high, they're nowhere near high relative to your $100 million type fallout that may happen as a consequence of not looking into these things.
When Alejandra was describing her idea, and actually I thought of a conversation me and Michal had a long time ago about Avanci, and I've had Lori Fitzgerald on my podcast, and that episode generated a lot of heated, I guess, passionate reactions. I almost didn't expect it. Obviously, I knew about them and all that, but I know some people just think they're being forced into this simplistic model where whatever you're doing, you have to pay one fixed fee. But you think economists would love it. You're saving all the efficiency from doing what they're doing instead of all that. Two things, I guess, there's probably other platforms and others trying to do what Avanci is doing, saying, all right, let's not worry about all these minutia detail. Let's just find a way to resolve it. You're not seeing as much progress as there is a success as Avanci has had in the vehicle space. From your experience, maybe I'd love to hear all of your thoughts about Avanci's idea and whether you think something like that is going to catch up in other areas.
I can start it. The world transacts at 7th grade math. That's the simplest thing. So that's 7th grade math. I think pools in general misprice the assets from my chair. So if you join it, you're getting it for the administrative convenience, and you're probably leaving a fair amount of money on the table. And that is, again, the same observation I have about large companies and how many folks are expert in valuation at a level like maybe some of the folks on the call here that are actually setting the price. Maybe they're using third parties or they have in-house. That's not apparent from what we can see. And so with that, those pool values are polluted or contaminated from the start. And then the allocations to the particular patent owners is something that is also fairly 7th grade math. So it doesn't necessarily mean that you're the one that's benefiting proportional to your contribution to the standard. Cellular is the easy one. If you add up all of the R&D investment from the major telcos that are developing, it's over $100 billion a year last time we looked at it. Just divide that by the 2 billion endpoints that come out a year. That's $50. There's not a team out there right now that says the tech stack for cellular is any more than, what, $16 or $17? And that's a number that they pulled out of thin air from everything that I've reviewed on it. It's not based in reality. The clearest example that we had for a pure play cellular network that was developed was Qualcomm with CDMA. They foot the whole bill. It was tens of billions of dollars. Apple doesn't want to pay the rate? Fine. Go build your own cellular network. You got the money to do it. Have at it. And they know they don't want to do that because they're not going to be successful at it. And the Intel modem fiasco really is just part of the example of that. But the point is that if you amortize just the R&D and not even accounting for economic profit on it, folks are already getting a super good deal out of these things just on the basic math. And people can argue that the numbers don't matter. But the problem is you have that same issue. It's compounded when you go into the pool. Because now you've got administrative things getting in the way, and there's a simplicity to reduce it to the 7th grade math. And so it makes it easy if you're the administrator, and let's say you've got to show good numbers for the fiscal quarter, but it's really bad for the long-term value of the assets.
Alejandra, your thoughts?
Yeah, I was going to add something about the Avanti, right? I think when we are talking about cell or SEPs, friend, right? The smartphone manufacturers have been at it for a longer time than the automotive sector. So this was a process of education where they started many years ago and they have been learning with the industry. And now you can see that people are becoming more sophisticated in how they negotiate this license. The automotive was kind of caught off guard. So then the simplicity is appealing because I don't really know all this world. Cars are starting to getting more and more cellular technology in them, but their lack of understanding, it was easy to be, okay, it's one rate, let's go. And I think as the technology becomes more and more available and cannibalizes not only the automotive industry, but other industries, these industries are going to learn a little bit with the smartphone industry and try to see what is that we need to pay attention. One of the things that I always like to bring attention to is everybody agrees that patents are territorial rights. And those negotiations are done for global licenses. So you need 3 data points to be able to establish a fair, reasonable, and non-discriminatory rate. The first one of it is point of sale. Where is the product being sold? Then the second point would be point of manufacture. Because let's say if I am an automotive manufacturer that I only manufacture in India and selling in another country and the licensor doesn't have coverage there, I don't pay royalty rates. And that's an important nuance to the whole scheme of what is fair, reasonable, and non-discriminatory. And then I guess, of course, you need to figure out where the licensor has the patent coverage. So those 3 data points play together to be able to establish. But we see this appeal of being like, oh, it's a global license, it's one rate, it doesn't matter where you manufacture, it doesn't matter where you sell. So I do think that this is important as back in the day, for instance, with the smartphones, a lot of smartphones manufacturing occurred in China. But we have seen in the last 10 years that a lot of companies are moving their manufacture to places like Vietnam and India. And then some of the sophisticated players in this space don't necessarily have a big patent portfolio in those countries. So then this becomes another nuance because, as I said, at the end of the day, patents are territorial rights. So you need to be able to triangulate those 3 data points to be able to see what is the royalty rate they're paying, because the point of manufacture sets your floor. So I think those are all important. And as the industry and the technology becomes more broad, adopted in every single other segment, not only automotive, but other people are going to learn with it and become more sophisticated. And hopefully us and experts have the opportunity to help them to get better deals.
So I guess bottom line is you don't think we're going to see this model replicated across all other technologies? If anything, it's going to become harder to do that.
Yeah, it's trickier because, as Mike said, people like the simplicity of it. But I am an economist, so I like to make everything complex.
Michal, I don't know if I mentioned, obviously, the rate you're talking about is whatever, $29 per vehicle, regardless. It's a self-driving Tesla or some car in China or something like that. Yeah. Any thoughts, I guess, about?
I mean, I think the issue still is that the auto industry literally got caught off guard, I think. And it's an older industry, and they've had things done the way they've done for 120 years now. And one of the things that developed around the IP, in particular in the auto industry, is especially once most car manufacturers became assemblers effectively, not developers of technologies, that they just assumed themselves to be indemnified from everything by the suppliers, both tier 1, tier 2, tier 3 suppliers. And even that mindset, I think we're at the edge of that mindset being contested and changed slowly at car companies, but we're not quite there yet. And that's just the first step. And that's very different from the cell phone industry, where the same companies who are developing the standards were working very closely together. They were competitors in certain areas or partners in others. It was just very different. And so I think that's going to continue to create barriers to trying to figure out what is the right model. But if there are any lessons to be taken from patent pools in the way they worked out in the mobile phone space or even the, say, 5G infrastructure space, I'd say that the car industry is also waking up to the idea that there are Apples and Samsungs of the car industry, and there are others, and that one size fit all is just not going to work out. And there are players sufficiently large enough at scale that should have the ability to go into cross licenses or create unilateral licenses with certain other participants now in the industry, while others may be willing and should be put to take some a la carte licenses, maybe primarily because of administrative burden, but for various other reasons too, because of the opportunity and ease and indemnification and freedom to operate and all other reasons that we often discard, but that actually when you're a growing business, or in particular for EVs, for example, are an important consideration. That's the last thing you need to worry about. So I think we're just not there yet. I would have to be really hard pressed to make a judgment of where that model is going to end up within the next 3 to 5 years.
Importantly, what overlays this is that value is contextual. The same asset can have different values depending on who owns it. What I find fascinating about the auto industry is that outside of carriers, they capture more of the value of cellular communications on a per unit basis than the smartphone manufacturers do. Because they sell a device and they're making $500, $600, $800 if it's a flagship device, maybe a little bit more. And somebody buys a connected car feature and it's a $1,200 option and a monthly charge. So they're doing way better just on a nameplate revenue basis. Now, they don't have the volume because there's less than 100 million vehicles that sell in a year in the world. But they have way higher marginal profit. So does the value of the asset contextualize to their particular use? And that depends on where you are in the supply chain. And so the closer you are to the end product, the better the rate, because the more value you're enabling. But there's a big push, especially from some in Europe, that it's the lowest cost use sets the rate for all use of the technology. And that's great if you want to enable the free riding, but the lowest cost use, if it's going in an IoT sensor for some small startup, is not going to be enough to pay for that $100 billion a year in R&D. So yes, but the abuse that happens is people try and take those different value contexts and say that they're the same just because they happen to be companies that use that technology. But the use of the technology is what's controlling, not the fact that it's owned by a company and it adopts or implements the same standard. That is something a lot of folks don't like, because then that allows for pricing that is contextual. But that's what we do in every other area of the economy, aside from basic raw materials. You want to buy aluminum? Yeah, aluminum is the same no matter what. It doesn't price differently. But how you use that aluminum will actually vary very much depending on how much additional value goes into it. And that's the thing I find fascinating. I don't have all the answers for it, obviously, but that's the one that I find is the interesting battlefront here, where that value contextualization is weaponized to drive different outcomes, pro-licensor or pro-licensee. I'm nonpartisan, so I don't really care, but I don't want to see abuse on either side of it.
So, Mike, you mentioned the data that you collect, and I know you collect a lot of data related to patent prosecution, which is earlier than some of the things we discussed. And when you kind of come into one of these licensing situations or litigation, the facts are what they are, right? You can try to find them or whatever. I guess anything that you've seen over the years, which was like, hey, this is something that maybe innovators or companies or patent prosecution attorneys should be thinking about when they're obtaining patents.
Yeah, there was a major focus on patent counting because the market understands that. Oh, you have a lot of patents, so we're going to value you more. Fitbit's a fun example because they had one of the largest, what I call patent trees or progeny trees that exists. At one point, a third of the entire Fitbit patent portfolio came from one parent application. So Huawei is probably the greatest example of that sort of abuse at a massive scale, and that 18% of their patent portfolio are what we call parent patents. The rest are continuations, mostly continuations, a few CIPs and divisionals. And so what that allows one to do, if they're unsophisticated, is believe that the patent countering rhetoric works. So that, tied with forward citations, are probably the two that we see a lot of emphasis, and a lot of folks misapply it because they don't have a full understanding of how those things come to be. And so what I've seen with the data, which is, I've got a 1.6 petabyte data footprint that I've built just to host all this stuff, and I pull about 100 gig of data a day. And it's just because it enables me to get just better insights. I built it out of necessity. I didn't come into this wanting to do it. I was a software guy. I knew how. And sometimes I look at the expenditures I've got into that, which is millions of dollars, and scratch my head. But it enables a business purpose. And that business purpose is to better understand the dynamics in the market. And so, patent counting is one. IBM went out of their way to structure patents for years where they would separate their method and their apparatus claims into distinct parent filings. And they did that to boost the patent counts. But what that also meant is that 37% of their assets in periods where I measured them might be terminally disclaimed. So they're paying extra money to get all that, and the assets co-terminate to others, and there's all sorts of other issues with it. But if their reward was get the most patents, then that's what they do. If you look at Apple today, I use them for examples because they're easy and there's good data. Steve Jobs is still patenting for Apple to this day. Now, if you read the press, he died 14 years ago, approximately. But since his death, he's been listed on over 1% of Apple's patent applications. Now, if you understand that and you look at the origin of the Apple patent portfolio and where its priority is, and it tends to be focused in 2011 or 12 or 17, and that was really because they were buying other people's assets, the Nortel estate, the Intel estate, and so forth, as opposed to coming from their own efforts. It really highlights the innovative gap that exists in that portfolio from my chair. It's data-driven. Why is Steve Jobs still patenting 14 years after? Why is Apple still patenting on the iPhone 3? Well, that's because of a design patent loophole. Now, this data enables me to make these kind of points, whether it's valuation for M&A, which is, just for context, most of the valuation that exists in the world is outside of litigation. Although, litigation gets the headlines, but most of the valuation that occurs is outside of that. So having that data to make a business case around something becomes super interesting. And that's how we started with it.
And I guess your point is there might be value in getting a lot of patents, but I guess you should be knowledgeable what that is.
Right.
Alejandra, how anything that sticks out to you from the valuations you've done?
It's really fascinating. I'll make a plug for Mike. I love reading his insights on LinkedIn and other venues whenever he's willing to share a tidbit out of his analysis of those petabytes of data. And just for those who might not have their units straight, 1 petabyte is 1,000 terabytes. So that's a tremendous amount of information that Mike's collected and that he's footprints. And I think everybody should be using similar data for investment purposes. I think in litigation, it's a little more tricky, but for investment purposes, for whether to assert something, does the value of information that can be gleaned out of data like that for validity, infringement, for any sort of, timing type issues, prior art, all that stuff, it's so, if you're going to pro forma value a patent even to a business at 100 million, but the probability of success is like 0.1% based on what Mike will tell you, don't go sue, because you're not going to get anywhere. You're just going to spend upfront money preparing for something that's going to get dismissed pretty early on. Just don't do it. And so I wish, even in my world, that more people were using that sort of information to make informed decisions about how to navigate the case, how to proceed, whether to go the patent litigation route or approach some sort of a negotiation in a contract base, how much to push, how to be reasonable in the context of whatever the pro forma number may be. But that's not what should be driving investment decisions or negotiations ultimately. And given that we live in this world where we have people like Mike working those sorts of databases, and now we're entering, I think there's some value to kind of commercial products that say LexisNexis and others offer as well, or Thomson Reuters. But combining the two types of expertise, I'm actually really surprised that not more of the bigger clients use those services routinely.
Alejandra, go ahead.
Yeah. So I guess my 2 cents, I think that from an expert perspective, every one of us has had the typical situation where you're doing a market approach and you have a license that involves a portfolio-wide license, but includes the asserted patent. And then our big headache is how do you apportion to the asserted patent? And this becomes a huge debate because I think like the industry recognizes that within a portfolio, the value of patents is skewed, but what makes a small portion of the portfolio carries a lot of the value, but which patents is where and how to figure out this whole analytics within that portfolio is one of the biggest headaches that we have as experts. I'm not sure that I have the precise answer of how to do it every single time, but I definitely know that not doing an apportionment is a big no-no in this industry. And the other point that I was going to expand a little bit on what Mike just said.
So you mean apportionment within the license?
Within the portfolio. Normally, we always encounter this when we can have a license that has the asserted patents, but is a portfolio wide. So then how do you apportion to figure out the valuation specific to the asserted patents becomes a big conundrum. And the courts are very picky on this and scrutinize all the models that we have provided. But what I was saying is there are multiple ways of doing it, but not doing it is no longer an option. The typical way to do it is when you say, oh no, the asserted patents carries all the value. That has been very neglected in courts. So you have to provide an analysis. If you're going to argue that the asserted patents carry the value of the license, you have to provide backup. You have to tie it to the facts of the case. You have to have a specific methodology. The typical, somebody told me at the company that they carry most of the value does not work anymore. So what we have been seeing is courts have scrutinized more on our opinions regarding to that specific issue of apportionment within a portfolio. And I guess the other thing that I was going to add was related with the data. Everybody loves data. However, I do think that it is important to understand that there's also errors in the data. And as experts, we need to make sure that we essentially fact check to make sure whether the data is reasonable. So specifically for standard essential patents, there are multiple companies that provide the Etsy database. But we see that not all of them are perfect. There's still issues. So that's why I say kudos for LexisNexis that they just launched the seller verified, which is essentially companies that are going to work with them to try to improve that data and make sure that that data provides reliable results. Then it makes it easier for the users of that data to kind of trust it a little bit more, because those are huge databases that go into an insane amount of coding, and the coding is being done by human, and human is prone to error. So having that fact check of any database and making sure the results you're getting are reasonable is essential for our work to make sure we have more symmetry and better results.
That opens up it's a fascinating, I'm glad you mentioned the data quality issue. We have over 1,000 rules that we run every night just to figure out a patent assinee's name is correct. There's a law firm in Indianapolis where I live that only types their name right on 78.69% of the applications that they file, which is kind of funny to me because it's automated now. But it's one of those things where that simple issue pollutes all sorts of stuff. Well, is the asset filed in Microsoft Technology Corporation or Microsoft Corporation or Microsoft Corp, which is their SEC name? These sorts of issues plague and creates variance. Now, whether it's material or not is something that you can measure. You know, the single largest source of error in the patent system, in my experience, is the S&E database. But if you factor that out, there's probably about 3 to 6%, depending on which part of that data you're looking at, that's going to be wrong.
All right, well, we're coming to the end, and I'll let you kind of share your final thoughts about this topic. But well, like I said in the beginning, one of the reasons I wanted to talk to all of you is because people in my field, I guess, or within companies, they think a lot about how to communicate the value of a patent program, but they definitely don't think about it in the same detail as you. So I guess maybe what are your final thoughts about patent valuation and any advice you would give to somebody who doesn't do it day-to-day, what they should think about when they think about values of patents?
I can start it. There's an ANSI standard that's forthcoming on IP valuation. It touches everything but trademarks. And I would recommend taking a read on that. It's mostly a due diligence checklist. The math is nothing that one needs to standardize. The approaches and whatnot are well defined. What the standard focuses on, and Alejandro's predecessor firm was actually part of that development at one point, I think CRA might have been at one point too earlier on in the process. But it really gets to what things you should be looking at to make sure that you get the math right. So I think if you have a good basis for what drives value and what the risk points are, you're going to make better business decisions and allocate scarce resources.
And I think all three of us can agree that the best advice that we can give is when you're, as a lawyer, or if you're trying to do any type of valuation, make sure you engage your experts soon enough, because we're going to provide you the tools and the methodologies to have a good case and make sure that you understand, right, where the risk is and where the rewards are.
Yeah, and the way of thinking. I'd sort of like to say that we would all point our clients to resources like that, but we also, I think, provide this basic level of intuition, which is, I think it just comes down to you're the business folks, you're connected to the business folks and the engineers, you understand the value if it's there. You just need someone to help you translate that value into actual dollars and precision, or to tell you whether that value actually does have dollars and cents or if it's something else. And ultimately, it'll come down to a cost-benefit analysis that I think intuitively may come easy to people, but when it comes to precision, it's really hard to have in-house expertise. The patent world is still so idiosyncratic, even for any single organization. There are going to be similar assets, but there's going to be a lot of diversity of assets. And we just collectively here have the benefit of having worked across industry and across literally thousands of individual patents. And probably by now, I think among the three of us, probably millions collectively if you combine the portfolios of patents we looked at. And that is a really difficult thing to develop internally. So I think if you have a hunch something's at stake, I think you need to look outward.
That's interesting. Having that external perspective helps how to tell that story in the best way possible. All right. Well, thank you so much for joining Clause 8. I appreciate you for coming on.
Thank you so much for listening. Don't forget that new episodes of Clause 8 come out every 2 weeks, so be sure not to miss it by subscribing at voiceofip.com or wherever you listen to podcasts.